The year 2000 stands as a watershed moment for anthropological engagement with human trafficking, marked by the United Nations Palermo Protocol and the U.S. Trafficking Victims Protection Act, which together established the dominant legal and discursive frameworks that scholars would subsequently critique. Anthropologists and critical theorists have approached this moment not as a neutral policy breakthrough but as a site of cultural production where particular narratives about victimhood, criminality, and agency were codified. Scholar Joe Doezema, in work published around 2000, drew powerful parallels between contemporary anti-trafficking discourse and the early 20th century white slavery panics, arguing that both relied on the figure of the innocent, chaste victim to justify state intervention while simultaneously stripping migrant women, particularly sex workers, of their autonomy and reducing them to helpless others, requiring rescue. This critique opened space for anthropologists to examine how the legal categories solidified in 2000 often obscure the complex structural inequalities that actually produce vulnerability. Rather than focusing on individual perpetrator-victim narratives, ethnographic research has illuminated how discriminatory institutional practices, economic marginalization, and social hierarchies render specific populations, such as indigenous women in Guyana or impoverished communities in Cambodia, susceptible to exploitation in ways that criminal justice frameworks fail to address. The anti-violence iconographies accompanying post-2000 advocacy, such as imagery of chains and cages, have been shown to sustain what scholar Annie Isabel Fukushima terms the coloniality of categories, trapping individuals within limiting dualities of criminal/victim or illegal/legal that cannot capture the messy realities of migration, labor, and survival. Reproduces the very power imbalances they seek to dismantle by prioritizing security over protection.